So hello to everyone. My name is Eduardo Melo. I'm a judge in Brazil. It's a pleasure to be with all of us, members of our International Association of Youth and Family Judges and Magistrates, and the public in general. I'm very pleased to organize this new webinar. It's a webinar based on a research our association has developed on child participation in juvenile justice. We are developing every year comparative researches in order to promote transnational judicial dialogue among judges from all over the world. We had a participation of 55 countries. And today we are going to discuss in this webinar one of the most important aspects of this research regarding the right of children to participate, which is the right to information. And we have chosen two specific countries that have developed very interesting strategies to promote these rights and to reinforce the right of the child to participate. So we are very glad and very honored to have two prominent judges from Japan and from New Zealand. First of all, Judge Ida Malosi, she's a principal youth court judge in New Zealand, and Judge Kohei Takata, who is judge or attorney from Family Bureau of the General Secretariat of the Supreme Court of Japan. So today we are going to have a presentation, first of all, from Judge Malosi, and afterwards from Judge Takata. And we have some time for questions and for discussion from the public and from myself. So thank you very much, both Judge Malosa and Judge Takata, for being with us. Please, Judge Malosa, you have the floor.
Thank you, Judge. It's my great pleasure to be participating in this webinar and to be doing so alongside my brother judges. This is an important topic, and I'm happy to engage in the dialogue from the bottom of the world, Aotearoa, New Zealand. I want to present this PowerPoint, which gives an overview of what we're doing in New Zealand in the child participation space, and also to talk to you about the right to information. Our legislation in relation to the youth court is found within the Oranga Tamariki Act, the Wellbeing Act for Children and Young People. And the purposes of this legislation is to promote the well-being of children, young persons and their families, whānau, hapu and iwi, whānau being the indigenous term for family, hapu sub-tribe and iwi tribe. It's a large piece of legislation which covers not only care and protection legislation, which sits within the family court, but also the youth justice legislation, which of course sits within the youth court, which I head in New Zealand. The purposes of this Act are set out in Section 4, and they are to promote the well-being of children, young persons and their families, etc. And the purposes are achieved by establishing, promoting or coordinating services. And one of the purposes is set out there on our screen, designed to affirm the mana tamaiti of tamariki. So mana tamaiti means the intrinsic value and inherent dignity of a child or
Just
young
Melissa,
person.
excuse me, we can't see
Yes.
your presentation. I don't know if you are already sharing it, but we
Yes.
can't see it.
Okay, thank you. So it's designed to affirm the mana tamaitis, and that's the intrinsic value or inherent dignity of a child or a young person's connection to their genealogy and culture. And importantly, for the purposes of this seminar, the objective is to provide for their participation in decision making that affects them. So that's specifically enshrined in our law. That one of the purposes of the Act is to provide for the participation of the young person. And then there's the purpose of the Act, which talks about promoting their rights. And that applies specifically to young people who are before the court for alleged offending or offending. So I've touched briefly on the purposes and now move to the principles, which requires that any court, and of course that includes the youth court, must be guided by the principle that a young person must be encouraged to participate and express their views about any proceeding. So in the youth court, we encourage that participation, and when we hear their views, those views must be taken into account. And I'll talk a little bit more in a moment about how we encourage that participation. So there is a duty on the court, a statutory duty on the court to explain proceedings to a young person before the youth court. And it must be done in a manner and in language that can be understood by that young person, which is a matter of logic. I'm sure you'll all agree. No point in explaining something to a young person that they don't understand. Many of you involved in youth justice will know that it's particularly challenging to explain the nature of more complicated proceedings to a young person in a language that is understood by them. In New Zealand, we have to be satisfied. We have to satisfy ourselves as judicial officers that the young person understands what we're saying to them. And when we make specific orders, either under the care and protection provisions or the youth justice provisions, we must explain to the young person the nature and requirements of the order. If there are any provisions for variation of the original order that was made, and also explain to them their rights of appeal. And while we're doing that, we have to be mindful of how much information is being imparted to the young person at that particular moment in time, so that becomes even more of a challenge, not just what we explain to a young person or how we do that, but also being mindful of how much information is being imparted in that moment. Counsel who appear before the court acting for those young people have similar duties to explain proceedings. And then we have a specific provision in our legislation which sets out the participation and views of young people. And I won't go through all of this slide, but you'll see that it covers every step of the process, a lot of emphasis on reasonable opportunities being given, support being provided to assist young people to express those views and to be understood. The requirement to take those views into account, and if those views are not followed, to give reasons why they're not followed, so a young person understands how the court has come to those decisions. And an overlay for all of this is explanations that are given in a manner and in language appropriate for their age and for their level of understanding. And that last point's an important point because it requires judges to have a lot of knowledge and understanding about what language is appropriate for the particular ages of young people, children and young people who come before the youth court. So that's a particular training issue that we focus on here in New Zealand and is an ongoing area of change and therefore need for update. In our country, the role of youth advocates, legal representation for young people is critical. All young people who appear before the youth court have legal representation. They can either engage a lawyer privately, which is very rare. Mostly youth advocates are court appointed, and again, there's statutory provision for that. Their appointment is based on personality, cultural background, etc. It's a position within our legal system that's highly sought after. There's strict criteria for appointment and a panel process that assesses suitability. So not everyone can become a youth advocate, and we try and keep the numbers relatively low to assure expertise is built up within the specialist jurisdiction. There's another key role within the youth court, that's the role of a lay advocate. This person is not a lawyer. They appear in support of the child or young person, and their role is to ensure that the court is made aware of all cultural matters, and they represent the interests of that child or young person and place before the court what is often really crucial understanding to, or really crucial information to help the court's understanding of the cultural context of this young person. Importantly, it's not a substitution for the very important role of a social worker for the young person. It enhances the information that a social worker and other professionals give to the court about the young person and about their family. Communication assistants are really important in the youth court. They're provided for not under the Oranga Tamariki Act, but under our Evidence Act. So they're available in the youth court and in the adult criminal court. They've become crucial in the youth court for young people who need assistance to understand the proceedings and to place their views about all manner of the proceedings that they're subject to before the youth court. They are expert communication assistants who add huge value to the proceedings in the youth court and typically are appointed when young people have been diagnosed with either intellectual disability, neuro disabilities, or mental illnesses. They're nearly always engaged when there are fitness to plead hearings that involve young people. The youth court has been at the forefront of using communication assistants, and over time we have seen them used more and more in the adult jurisdictions as well. So in terms of young people in New Zealand participating in their proceedings before the youth court, they have the support of a youth advocate, a lay advocate, and a communication assistant as well, where the court deems that that's necessary. I just want to move quickly on to the right to information and what information a young person is entitled to when they are before the youth court. And the first point I want to make is that their entitlements are the same as those for adults in the criminal jurisdiction. And I won't go through this in any great detail, but essentially we have four main points of disclosure. The initial disclosure as soon as proceedings are commenced. There's then a further disclosure as soon as reasonably practicable after the young person, through their youth advocate, requests it in writing. And then there's full disclosure if a young person denies the charge and it's headed to trial. And then finally, there's additional disclosure which the young person can request at any time after full disclosure has been made. And then there's the ongoing requirement of the prosecution to continue to give disclosure as the proceeding progresses. Our young people before the youth court will typically receive that disclosure directly from their lawyer, who will sit down and go through that with them and also leave that with them to consider in their own time, to the extent that that's possible for them to do so. So that is a quick romp through child participation and right to information in New Zealand. And what I'm going to do now is stop sharing, or at least attempt to do that, and hand back to you, Eduardo.
We haven't seen the presentation. It was only you speaking, as I said to you, but it's fine.
Oh, sorry. I thought you said to me that you could see the
No, we
presentation.
couldn't see. No, we couldn't see. But it's fine. I don't know if you want to show some slides. It's okay. We have some time specifically, or yeah, now it's appearing. But we're seeing, yeah.
Well, can you see that now?
Yes, now we can see it.
Well, that's not helpful, is it?
Yeah.
Well, I will make that available to you, Eduardo, and you will be able to
To share with our.
share that potentially.
Yes. Yes, but if you can show it as we are publishing it on YouTube, if you can just show the slides so everyone can stop and read afterwards, just to have a quick look. And it was very interesting, your presentation. Yeah, and now when that we can see the overview of the disclosures.
Yes, I think it's a bit difficult to follow, and I'm sorry to those that are live and have taken the trouble to join live that you didn't have the slides in front of you. But they will be made available, and they do
Yes.
summarize the position.
Okay.
So I'll just close that, stop sharing.
Okay. Thank you very much, Ida. It was very interesting, and I'm sure that we have a lot of questions about your presentation, which will highlight and stimulate us for this discussion. So it's a pleasure now to give the floor to Judge Kohei Takata from Japan, from the Supreme Court of Japan. So it's a pleasure again to have you with us. Please, you have the floor.
Good morning, everyone. Thank you for inviting me such a wonderful event. It's my pleasure to be here. And actually, I'm feeling a bit nervous because my first presentation in English for webinar. I'll do my best. My name is Kohei Takata. I am a judge attorney working at Family Law General Secretariat of the Supreme Court of Japan. I think this judge attorney system sounds strange for you. So let me explain about my work first. I belong to the Supreme Court of Japan, but I'm not sitting on the bench as a justice. In Japan, there are some judge attorneys working at our Supreme Court in order to do housekeeping job for courts to help lower courts. For example, revising court rules when laws are revised by the Congress, giving advice to lower courts when they make a reference about unusual cases, or when they get an interview from press about the incidents, and doing research on foreign justice system as well. These housekeeping jobs don't look like judges' jobs, but judge attorneys are all qualified judges, and they were and will be working as a judge at district, family, or high court like you. I am one of them and working at family law and managing juvenile branch. I was working as a judge for 10 years before starting working at the Supreme Court from this April. So now I'd deliver presentation about the right to access the information and effective participation. But I'd like to introduce our juvenile justice system first to have you better understanding my presentation. Now I'm sharing screen. Just a moment, please. Can you see me?
Yes, we can.
Okay. Okay, in Japan, the family court has jurisdiction for juvenile delinquency cases. In principle, juvenile under 20 years old are subjected to the jurisdiction of the family court. And the minimum age of criminal responsibility is 14 years in Japan. Proceedings of juvenile cases are as shown in this chart. Police officers, public prosecutors, or child consultation centers director refer the case to family courts after their investigation. When family courts accept a juvenile case, judges order family court investigating officers to carry out an investigation. Family court investigating officers are court staff and utilize the specialist knowledge and skills acquired through the study of behavioral sciences such as psychology and sociology, and conduct interviews with juveniles and their parents. Investigating officers then examine the motives behind the delinquency, the personality of juveniles, life history, and so on, in order to ascertain the best possible course of action to facilitate the rehabilitation of juveniles, and then submit a report to judges. When judges consider it to be desirable to investigate the physical and mental conditions of the juvenile in more detail so as to appropriately decide on the measure for juveniles, judge may commit juveniles to a juvenile classification home. Juvenile classification homes are facilities that accommodate juveniles and conducts mental and physical identification while observing their behavior, and then submits a report to judges. Juveniles and parents attend hearing. Judges and court clerks, investigating officers, defense attorneys attend as well. In some cases, teachers, family members, other than parents, and employers of juveniles attend hearing when judges grant permission. Judges, investigating officers, and defense attorneys can ask questions juveniles and parents. Juveniles must attend hearing according to the juvenile code. Judges rule to impose a measure for juveniles based on the results of the investigation and hearing. There are some orders juveniles may have, but most of them are protective measures. The protective measures include probation, where probation officers provide guidance and supervision to the juveniles, and referral to juvenile training school, where the juvenile is committed to a specific facility to facilitate the rehabilitation of the juvenile. Okay, and I'll move on next part. Next, I would like to introduce some ideas about the effective participation of juveniles. First, in our justice system, the relationship between juveniles and family courts investigating officers are very, very important. As you know, juveniles are likely to have fear or anxiety regarding the court, which will decide the juvenile's disposition. Therefore, it is important to give consideration to such sentiments and to encourage dialogue through forming a sense of trust between juveniles and investigating officers. When family court investigating officers interview with juveniles, investigating officers generally make juveniles understand that juveniles will not be forced to make a statement and explain the purpose and significance of the investigation in an understandable way. According to juveniles' ability to understand, in order to encourage juveniles to voluntarily make statements. Vigorous participation in investigation helps investigating officer understand the background of juvenile and submit better report to judges. Second, atmosphere in hearing court is also important, I think. Japanese juvenile code provides that hearing must be conducted cordially and amicably. Judges must preside over hearing kindly and gently. The atmospheres of juvenile hearings are completely different from that of criminal court. The hearing is not structured in a formal way, but more open to a dialogical interaction with juveniles. We judges make a serious effort to encourage juveniles to participate effectively in the hearing because the dialogue between judges and juveniles are crucial material to decide the case. We never use jargons, intimidating attitude, wear gown and wig. Actually, we wear gown in criminal court and do not wear wig though. In addition, more and more juveniles have difficulties in making verbal communication with others. Thus, we judges try to guess what they are thinking about from their small gesture. Also, investigating officers who have already formed a sense of trust with juveniles sometimes ask supplemental questions juveniles when juveniles seems not to understand well what judges are asking. I believe these two ideas, the good relationship between juveniles and family courts investigating officers, and kind atmosphere in hearing court, contribute to effective participation of juveniles in juvenile justice system. Now, I'd like to move on the right to access information for juveniles. I'd like to introduce general measures to grant the right to information in Japan first. First, court clerks send a brochure to juveniles. This brochure informs juveniles of their rights and juvenile proceedings. What I attached to the report was this material. I will show you this material later. Second, before the hearing for the detention measures to a juvenile classification home, court clerks explain the procedure and the right of the juvenile. During the hearing for the detention, judges explain the right to remain silent and the right to counsel. When juveniles are sent to a juvenile classification home, court clerks generally make juveniles understand what a juvenile classification home is, what the juveniles will do there, what will be following process. Third, when family court investigating officers interview with juveniles, investigating officers generally make juveniles understand the proceedings and the right to attend the hearing and remain silent, as well as the purpose and significance of the investigation. In addition to the measures I mentioned, in the beginning of the hearing, judges explain the right to remain silent, and after the proposition, judges explain about the right to appeal, if possible. And now, let me introduce the brochure for juvenile delinquents. I'd like to share screen again. Can you see it?
Yes.
Okay. We send this material to juveniles so as to inform juveniles and parents of the procedure, the disposition, and the right of juveniles and parents. This material starts with the scene that the Mr. Minato, who committed robbery, his classmate, of money, is arrested by the police in scene 1. And in scene 2, the police officers are interviewing with him. In scene 3, this case were sent to the prosecutor, and the prosecutor sent the case to the family court. After the prosecutor's investigation, he looks like annoyed. From scene 4 to 6, the judge is asking him some questions in order to determine whether the juvenile should be detained in juvenile classification home so as to examine the juvenile in more detail. The judge is asking, the prosecutor insists that the juvenile robbed his classmate of money. Is it correct? In scene 7, it is written that the juvenile has a right to counsel and remain silent. In scene 8, Mr. Minato was sent to juvenile classification home and detained there. Also, the chart of proceedings are written left side of this page. Scene 9 explains what the juvenile classification home is. Scene 10 explains the role of family court investigating officer. The investigating officer investigates the personality of the juvenile, his daily life, and the relationship between family members, friends, co-workers, and the juvenile in order to get the idea how the juvenile rehabilitate. Ms. Miyazaki is the investigating officer of this case. In scene 11 to 18, she is interviewing with the juvenile and asking him the reason he didn't talk with his parents about his worries, although he needed money. Then, in scene from 19 to 25, the investigating officer is interviewing with his parents and telling him that the juvenile was not able to talk about his worries. The parents looked surprised to hear that, and they recall that the juvenile shuts himself in his room recently and did not have enough communication with him. Scene 26 explains who attends the hearing and how is the proceedings going. In scene 28, the judge is asking the juvenile what he thinks about the victim who cannot go to school because of his delinquent. In hearing, the juvenile is allowed to freely speak about his family condition, educational process, and social experiences, as well as wrongful act. In scene 33, The parents are telling the judge that they did not realize that the juvenile had worries about money, and they promise that they will talk more with the juvenile and listen him talk attentively. In scene 34, the judge ordered release him from the juvenile classification home and ordered tentative probation by family court investigating officer as well. In scene 35 to scene 39, during the tentative probation by family court investigating officer, the juvenile apologized to the victim and participated in cleanup activities with his parents. In the end, in second hearing, the judge ordered final decision. This page explains that what are orders or proposition the juvenile may have, and also explain the right to counsel, right to remain silent, and right to appeal. Okay. And okay. Let me explain something about this material. First question is, why have we developed informative material for juveniles? As I explained before, Japanese juvenile proceedings are a little complicating and hard to understand for juveniles when they are explained without written papers. We want juveniles to understand enough juvenile proceedings before hearing and investigation by family court investigating officers. Manga-style material is good for juveniles to understand juvenile proceedings easily because I think it attracts their interest. And the next question is, how is this material used? Court clerks send this material to juveniles as soon as family courts accept a case. Juveniles and their parents use this material to learn proceedings and their rights before investigation and hearing. And what was the impact of this material on child hearing in juvenile justice? This material makes it easier not only for juveniles to understand how to proceed, but also for judges to preside over cases smoothly because juveniles already have their minds what is going on and what will go on. To add more information about other strategies developed to grant this right, family courts send parents another document which explains juvenile proceedings and the right of juveniles and parents. Also, family court investigating officers explain how to proceed and the right of juveniles again and again to juveniles by using a child-friendly language and in gentle atmosphere when investigating officers interview with juveniles. I believe that this explanation by investigating officer is actually the best way to grant the right to access information and effective participation actually. Japanese juvenile justice system still has room for improvement, but I have confidence that family court investigating officer system in Japan contributes a lot the right to access information and effective participation, as well as the material I introduced today. I understand that there are some differences between our juvenile justice systems, but we all need to grant juveniles the right to information and effective participation. I'm glad if my presentation will help grant these rights in your country. Thank you very much.
Thank you very much, Judge Takata. It was very interesting and very exciting to see all this manga style information brochure. It's very interesting. I am sure that children should be very attracted by this material. Well, we have some time. I have some questions for both of you because I saw that both countries are very concerned about how children will be effectively able to understand the procedure. And both of you mentioned the issue of training. So on one hand, I would like to understand a little bit, how do you train judges to have an effective communication if you are aware of this procedure? And on the other hand, if you check with children somehow, in general, if this material or if this communication is on their point of view, on their perspective, is really clear, because sometimes we had during this research a very interesting conversation with the Netherlands, and they prepared videos and materials, and when they began to make researches with children, they said it's not child friendly at all. We cannot understand, it's very complex. So this is a very challenging issue. How do we train judges on one hand, and how do we check if children really understands what the message we want to deliver? So I don't know if Judge Malosi would like to make some
Sure.
comments on that.
Yeah, I'm happy to attempt to respond to that in two parts. The training of judges is challenging, but less challenging than trying to satisfy yourself that the young person understands what's been happening in court. So in New Zealand, like many countries, we have a dedicated school for judges, the Institute of Judicial Studies, or Te Kura Kai Whakawa, we call that here. So we have training seminars that are dedicated for youth court judges, and the training centres on all topics in relation to young people, including the fine art of communicating. So we try and stay up to date with the latest research practices in relation to effective communication with young people. We know that there are those time-honoured traditions of checking people's understanding of what we're saying by reflecting back what they've just told us, asking them to tell us in their own way what they've understood about what we've explained to them. Time is a friend when communicating with young people, taking the time, slowing things down, and constantly checking in about their understanding. But it's an ongoing challenge in the youth court, but it also, in my experience, helps me to become a better judge, because young people in our country are certainly not shy in many cases to tell us exactly what they think about our judging. So it's confronting sometimes to be midstream explaining something to a young person and they get impatient because I'm taking too long or using big words that they don't understand. So they certainly let judges know when they're not engaged in the proceedings because they don't have a clue what's going on, because we haven't fulfilled our role as judges to explain that plainly. So an ongoing challenge for all of us.
Yes, it is. Judge Takata, what is your
Yeah,
experience?
Yeah, it's very interesting question. And the first, we have the training activity school or institution in Japan, and their judges can receive some trainings, like Judge Ida mentioned. And actually, family court investigating officers have received various training and have acquired specialized skills, not only through training, but also through participation in research and academic meetings concerning interviews. And also for judges, judge can participate in juvenile cases training, and they learn how they communicate with juveniles and how to attract their intention, and how they enable proceedings to be understandable way for juveniles. And second, as you said, I think judges may not understand whether juveniles really understand the process or what judges are asking. So we judges are trying to explain plainly and slowly if needed. Also, as I mentioned, investigating officers who attend the trial hearing, and they have already formed a sense of trust with juveniles. So sometimes ask supplementary questions juveniles in hearing when juveniles seems not understand well what judge is asking, or juveniles seems not understand well about proceedings.
Thank you. I have another question as well about the legal consequences of this lack of information. We know that in Europe, the European Court of Human Rights has been called to appreciate a case from England that the right to information was not properly provided to children. And I would like to know if you have situations like that in your country, that decisions, judicial decisions are challenged or appealed because the right to information is not very well granted. And what are the most, if you have, of course, and what are the most common issues that appear in those situations?
In New Zealand, disclosure or the lack of disclosure, the lack of timely disclosure can often form the basis of an application for the charges to be dismissed because of the prejudice to the young person and not being able to consider crucial information to support their case. So that's in many ways, people would see that as the ultimate consequence for information not being provided to a young person, and indeed a defendant in the adult court for that matter. It does put the charges at risk because the court, of course, has a duty to ensure fair trial rights for young people are protected, and particularly for young people who are vulnerable by virtue of their age, but also sadly by virtue of any number of disabilities and disadvantages that they face. I think that's probably a experience that's common across all juvenile jurisdictions.
In Japan?
I have no idea because I think there is no case to appeal because of the lack of information for juveniles. But I have to explain a little about disclosure system in juvenile system in Japan. Actually, all evidences, including report made by family court investigating officers are disclosed to defense attorney after the case is accepted by family court. So from disclosure system perspectives, there is no problem to grant the right to juveniles, I think.
And I have one specific question about for New Zealand and another one about another topic to Japan. Can you explain a little bit what's the professional background of this communication assistant in New Zealand? Is it a psychologist, and how do you identify that these cases need this kind of professional? Because as far as I understood, they only participate in specific cases, not in everyone. So is there a previous evaluation, and what's their qualification, professional qualification to participate on that?
So they are all professionally qualified in the language linguistics field, as I understand it. They are asked by the court in some cases, as you quite rightly point out, they're not appointed on every case, frankly, nor is their capacity in that sector to provide assistance on every case. So they are in the initial stage asked to provide a report as to whether or not in their professional assessment a communication assistant is required, and then to make recommendations to the court about how the communication assistance will then be used in the proceedings. So in the early days, it's fair to say they were appointed at the beginning and they were used throughout the whole proceeding until the end. We've now become more nuanced about which part of the proceedings they are required. Sometimes they might only be required to sit down with the lawyer and the young and go through the charges and assist them to make decisions around pleas, for instance. But you're quite right, they're not used on every case, but where they are, typically a young person will have some identified disability that is a barrier to their full and effective participation in the proceedings.
And do the children have to accept this communication assistant? Because there are some countries that have some ethical issues about bilingual children and they don't need a translator. And sometimes when the judge realizes that for native language is not so good as it could be needed in that case. So do children have to accept the communication assistant or not?
That's a very good question, because I've never had an experience myself where a young person has refused to engage with a communication assistant. By the very nature of their role, they are highly skilled and attuned to working with people who have difficulties communicating, and therefore are really, really skilled at engaging young people in the process. But there's no doubt that young people often see a stigma in having a communication assistant and, for instance, having someone draw pictures for them in court to understand the proceedings. There are some stigmas that young people attach to themselves and don't want a communication assistant because they don't understand. So it is a challenge, but they're so skilled in my experience about engaging young people in the process. And young people pretty quickly see the benefit in sitting in court all day and actually being engaged and understand what's going on, which of course increases the legitimacy of the court if young people see that they're able to participate and understand if it's fair or if it's not fair, being able to put their views before the court about what they think should be done differently or what they think full stop.
Thank you. Very interesting experience. We don't have a communication assistance here in Brazil. Do you have in Japan? Do you have some kind of experience like that in Japan? Someone who could assist the children who have some kind of communication disability? Judge Takata.
Yeah, I think that there is a few cases disabled juveniles or have difficulties in communicating with others. But we have not only have the translator when they disabled, and also we have a family court investigating officers. They are expert in psychology or sociology, so they can help communicating with juveniles when juveniles have difficulties in communicating with others, I think.
And I would like to just clarify if I have well understood about this brochure. You said that the clerk sent this brochure to the young people and the parents also receive another document. Does someone read the brochure with the young people, or you just send it by mail, or another, they have to understand it by themselves?
Basically, the court clerks just send the brochure to juveniles, but when juveniles ask the court clerk or family investigating officers about procedure, court clerks or family court investigating officers explain about the proceedings or their rights by pointing out a brochure or a reading brochure, I think.
Okay, thank you. Well, we have no more questions, so I would like to thank you very much. I don't know if you want to make some final comments, but it was a pleasure to have both of you with us today. And I'm sure that all our audience will be interested in knowing in deep the Japanese and the New Zealand experience. I remember that we have your national reports in our research, and I hope to have an opportunity to be with you, Judge Takata and Judge Malosi, once again in another webinar, maybe on another topic. So thank you very much, and if you want to make some final comments, it will be a pleasure to hear you.
Only to thank you, Judge Milo, for your dedication to this organisation. The research is really, really important, and these opportunities to come together and drill down into particular topics is a welcome opportunity. And I thank you both. It's been a pleasure.
Thank you. Judge Takata, if you want to speak something, otherwise it's...
Yeah, it was a really interesting meeting with you guys, and the communication assistance system in New Zealand is really, really interesting for me. So it was really good opportunity to run foreign juvenile systems and the right to information and effective communication. We have the various systems, and we are all different. We have all different kind of juvenile systems, but our purposes or our challengings are almost same, I think. So today my presentation or Judge Ida's presentation will help your country improve your own juvenile systems, I hope. Thank you very much.
Thank you. Yes, I think every country has its own strategy and very interesting and innovative strategies. So when we bring all countries together, it's very important to have inputs of new things that we can all develop. So thank you very much and have a nice day, everybody.
Thank you.
Bye-bye.
Thank you.